Hello everyone, welcome to the first installment of our final piece of course material. This week we're taking a look at Will Waluchow's Constitutions as Living Trees and Idiot Defense. Now, last week we saw Jeremy Waldron provide an argument, a right-based argument against bills of rights or charters of rights, really enshrining rights at a constitutional level within a liberal democracy, or really in a democracy in general. And the very short version of that argument ran something like this. It might seem like a good idea to put certain rights on a constitutional level in a democracy, but ultimately what that opens the door to is judicial review. What you have is power being given to judges to oversee and potentially strike down legislation, which in a democracy is really the will of the people. So in a democracy, citizens govern themselves, and they do that by electing representatives to the legislature. Those representatives then pass pieces of legislation, which then create law. We get rights through the law. Right? Whether or not you have a right to something or from something all depends on how the law actually functions within the country. The way the law functions really reflects what people want. So the rights we actually have in a democracy are a function of what rights we as a people think we ought to have. If we want to change them, then we elect different people to the legislature who will enact different pieces of legislation to change what those rights are. By putting rights in some kind of constitutional document, we allow judges a kind of outsized power over the legislature and the people's representatives, because they gain the ability to somehow overrule the will of the people. That is less democratic than letting people directly determine what rights they have through the legislature, through their elected representatives. Additionally, there's an objection here that even if we think there isn't really a big problem with judges conducting judicial review, then people from the past have a kind of outsized power over people from the present. Presumably, whenever that constitutional document was put together, the rights that are enshrined in it were the sorts of rights that a majority of people thought that the people in a given society ought to have. Now, of course, by putting it in the Constitution, we are making it harder to change those rights, what they are and how they function, than we are normal pieces of legislation. So in normal pieces of legislation, depending on precisely how the procedures work in the democracy, generally speaking, as long as we have a majority vote in the legislature, you can pass a new piece of legislation and thus alter or repeal old laws or create new laws, which in turn will change, eliminate, or create new rights. But as soon as you have something put in the Constitution, it's much harder to actually affect that kind of change. No longer is it just a majority vote in the legislature that's required. Depending on the exact procedure set up within the political structure and the legal structure in a society, you might need not only a majority vote in the legislature, you might need a supermajority, so more than a simple majority. You might need some, 2/3 threshold or 4/5 or whatever it might be, so more than just 50% plus one. You also might need some other kind of majority, say a territorial majority, different jurisdictions, say the different provinces and states, each voting on it, potentially through a referendum or something like that. So it becomes very difficult to change rights that are enshrined in the Constitution. And so effectively doing so, if people today have this much weight, right, any majority decision, what they can do in the legislature, because constitutional rights are harder to change, the majority view from the past is actually given preference. It's worth more than the majority view in the present. For both of these reasons, that judicial review is less democratic than allowing changes directly through the legislature, and because giving the past majority more weight than the present majority, both of these Waldron things are really good reasons not to have rights put in a constitution. So really, it's an argument from democracy and from rights themselves, namely participatory rights within the democratic process, that Waldron thinks we shouldn't have particular, say, individual rights, or really just rights in general, put into a constitution to then govern how a democracy is supposed to function. What we're going to see in Waluchow is precisely an argument to the contrary. Waluchow argues that, in fact, constitutions, and he's going to use the language really of charters. That's really the same thing. Last time I was talking a lot about bills of rights. That was the kind of language Waldron was using. Reflects something of an American influence. Waluchow's a Canadian academic. He's at Master University in Ontario. So here I want to be using the language of charters a lot. That's really the same as the language of a bill. So Bill of Rights versus a Charter of Rights, from what we were talking about last time with Waldron. So Waluchow is going to give us this argument that, in fact, charters are a good sort of thing to have, but that argument, as we're going to see, depends on how we conceive of charters, what we think these things are, and what kind of role they play within a democracy. So, as with Waldron, we're just going to walk through the Waluchow piece section by section. We're going to get through part of it today, and then we'll finish off on Wednesday. So, first, in this first section, setting the stage. Here, Waluchow explains what he takes to be really the shared view or shared conception of what a Bill of Rights or Charter of Rights, some kind of set of constitutional rights. He outlines this shared view that's accepted by both advocates of doing this, so people who think it's a good idea to have some kind of Charter of Rights, as well as critics. And Waldron, of course, is the main critic, and really ultimately Waluchow wants to argue against Waldron in this piece. Now, the view, the shared view, is precisely this, that the role of a charter or a Bill of Rights is one of providing a more or less stable, fixed point of agreement on and pre-commitment to moral limits to government power. So it's precisely a question of what sorts of rights do we think people have, and these are really moral questions about in what areas do we think governments can't intervene. What can governments not do to people? Even if there is a majority view that says maybe the government should be able to, right? Because of course, if we're trying to set up certain constitutional rights, in some sense, we think those rights should be established over and above the usual sort of everyday conduct of the legislature and the representatives of the people in there making new laws and thus altering people's rights. So what sorts of backstops or fail-safes or foundations or ultimate limits, or maybe not ultimate limits, but what do we think the limit should really be on this kind of thing? And so the whole idea here in the shared view is that there's this kind of pre-commitment to establishing some kind of stable, fixed point. And it's precisely this kind of view that Waldron takes. Of course, Waldron does entertain the notion of, within a given charter or Bill of Rights, you can either have mechanisms to allow change or not. Now, Waldron himself says if you're going to have something like this, you really ought to have mechanisms for change. Waluchow would definitely agree with that. But even when accounting for the mechanisms for change, Waldron himself still thinks that having charter rights is really less democratic than just letting the legislature establish all rights. Now, in next video, and on Wednesday's video, we're going to see Waluchow take aim specifically at Waldron's argument and what he takes to be some of the shortcomings in that argument. But ultimately, what Waluchow is going to do here in this piece is really defend the use of charters against Waldron's critique, which he takes to be really the best of, and in some sense representative of, the critiques that the critics have leveled against using charters in the past. So, to do this, Waluchow is going to propose an alternative conception of charters, about what their role is. Now, he puts it this way right in the first section. We're going to see him elaborate on this. We're going to hear more about this conception today. That's really what we're going to work through. And then next day, we're going to really see how Waluchow engages with Waldron's specific argument, and ultimately why Waluchow thinks that the kind of charter he's putting forward here, the kind of conception or the sort of role he has in mind for it, is in fact a really good idea to have within a constitutional democracy like Canada. So Waluchow puts it this way. He says, I'm going to suggest that we instead view charters as representing a mixture of only very modest pre-commitment combined with a considerable measure of humility. Think about that compared to the way Waldron characterized it in the previous reading. Waldron says, really, instead, to have constitutional rights entrenched in a charter actually suggests that we are very confident that we've got rights right. That is, we have the correct view on what rights are and what they should be and how they should read, and what sort of language they should be put in. So we've got a lot of trust in ourselves. We also have a lot of mistrust in our fellow citizens. That is, we don't trust them to stick to this realization of the correct view of rights that we now have, which is precisely why we need to write them down in some canonical form and limit the ability of future majorities to make alterations to our rights. So Waldron thinks the desire to have constitutional rights displays or is evidence for a couple of very different attitudes compared to what Waluchow does. So we're going to hear more about that next day, but this is some of the basic difference between them is just in some sense these background conditions, what they think the desire for wanting constitutional rights itself exhibits or displays in terms of attitudes of the people who want them. Okay, so that sort of sets up the basics of what Waluchow is going to try to do here. Now in the second section, there's really a couple of different things that go on. First, Waluchow points out 4 different questions that need to be disentangled. So we need to analytically distinguish between 4 different questions. So we'll look at that first. And then he also takes a look at anti-charter arguments. The sorts of arguments, the sorts of reasons that typically get marshaled against the view that we should actually enshrine certain rights within a charter. Okay, so these 4 questions. First, what role does a charter play in a constitutional democracy? We're going to see really what Waluchow is trying to do here is to formulate a different answer to that question than he thinks is currently shared by both advocates and critics alike. So the standard answer to this is what we just saw on the previous slide, namely that a charter provides this relatively fixed point concerning rights and so on. Now, Waluchow thinks that is true certainly to some degree, but we're going to see he thinks there's a different way to conceptualize what's going on here, what that role is really supposed to be. 2, is a charter, serving that particular role outlined in 1, a good thing to have in a constitutional democracy? And if so, why? So Waldron has the usual answer to 1, having a charter or Bill of Rights, having constitutional rights, really provides a kind of backstop or a limit to what a future majority can do, or at least what they can do easily in terms of changing rights. He thinks the answer to question 2 is no, having a charter really isn't a good thing to have in constitutional democracy, precisely because that role itself is really anti-democratic. So it's not good to have a charter that's playing the role outlined in 1, because that limits the ability of people to govern themselves, which really runs against the conception of people we need to have to really be Democrats in the first place. 3, is judicial review on the basis of a charter a good thing to have in a constitutional democracy? And if so, what form should it take? Now, of course, Waldron's answer here again is no, judicial review is not a good thing. That's judicial review again being really investing judges with the power of striking down or altering legislation somehow on the basis of the rights put in a charter. Waldron says, no, that's not a good thing, because now you're empowering some small group of judges with the ability to override the legislative intent of the majority, right, the people in a society. And not only is that less democratic than letting people just directly govern themselves, it also gives extra weight to past views, and this is often called, now, Waldron didn't quite use the language, but Waluchow does in a few places. This is often called the dead hand of the past argument, that people who are now dead and past, who were drafting the constitutional document, had certain ideas, and there had to be some kind of consensus amongst them, or perhaps the majority of people they represented, about what those rights should be. But now they're all dead and gone. yet us living in the society today are still constrained by what they wrote and the ideas they had in a way that has more influence than what the majority view today holds. Fourth, a more practical question: how should judges go about interpreting and applying charters in the context of the judicial review of legislation? So Waluchow is going to offer a different answer to question 1. That's really the aim of the next several sections of this piece. That's really what we're going to see today in this video. On the basis of his alternative answer to question 1, he's going to give an affirmative answer to question 2, that yes, it's actually a good thing to have a charter in a constitutional democracy. And then next day, we're going to see him offering an answer to question 3, really, is judicial review on the basis of a charter a good thing to have in a constitutional democracy? Waluchow is going to answer in the affirmative. In fact, that is a good thing to have. And it will depend in part on some of the details, both what role the charter plays, as well as how it is, so a little bit on 4, about how it is judges go about actually interpreting and applying charters. So we're going to hear a little bit about question 4, but really this piece focuses more on answers to questions 1, 2, and 3. Because of course, question 4 is this rather practical question, and now you're getting into a lot of details about how these things are going to work. So this gives us a bit of an outline just of where Waluchow's headed. We're going to hear a pretty good answer to question 1 today. We're going to see that gives a yes answer to question 2, and then we're going to get a yes answer to question 3, and we're going to hear the details about that on our next video on Wednesday. Okay, now these anti-charter arguments. Waluchow goes through these. They each get just a little bit of space, so I'm just, I just have the names of each of them. So these are just the section titles he has. And then I'm just going to give a very brief verbal description of what's going on with them. Some of these are going to be familiar from Waldron, including the very first one. No, I got way ahead of myself. That's on another slide. First, there's a couple more points to be brought up concerning that first question about the role of a charter. On the shared view, so the normal, common view shared by advocates and critics alike, Waluchow points out that we generally get these points coming up. So when we're considering what role a charter plays, well, minimally, charters help protect minorities from the tyranny of the majority. And remember Mill here. If you've got a democracy, you can easily get a situation where the majority votes in favor of something, right, whether it be a question of rights or whatever it is, but they use the law as, in some sense, a kind of weapon, and they can use that to tyrannize the minority by, say, passing laws that restrict their rights or unfairly target them, and so on. So charters help protect minorities by enshrining certain rights that can't easily be overridden by simple majorities in a legislature. This is a kind of pre-commitment strategy to protect certain fundamental rights essential to 2 things. First, a light and democratic rule, and second, the free and equal exercise of individual autonomy. So in practice, what's this going to look like? Well, this is going to include a set of rights that all people as individuals have, which include just so the 2, ultimately the sorts of rights we're talking about there in A and B. Participatory rights within a democracy, so the ability to vote, stand for, parliament, be able to stand for election yourself, be a candidate, be involved. Rights concerning free expression, conscience, association. The sorts of rights required to participate in the democratic self-governing process, as well as, of course, rights that just protect individuals from harm. So if we think in terms of Mill's harm principle, so rights concerning privacy, bodily integrity, protection of property, and so on. So this is really the role that a charter is going to play, guaranteeing certain basic rights and freedoms that we think everybody should have, even if sometimes we worry that majorities might want to vote those rights out of existence. Okay, now we come to the brief survey of arguments against charters, as outlined by Waluchow here. This is where we're going to get that brief summary based on the titles, and some of these arguments, in fact, basically all of them show up in Waldron somewhere or other, and we saw some of them pretty clearly in the Waldron reading from last time. All right, so argument one, the argument from democracy. I basically already summed this one up, so I'm not going to waste too much breath on it. This was really the overall point Waldron was making, that in fact, having a charter enforced through judicial review is really less democratic overall than is allowing people to directly determine what their rights should be through the use of legislation. And this is where we get that dead hand of the past objection, that by having a charter, we're really privileging a majority view from earlier time instead of the majority view today. Second, Hobbesian predators and respect for persons. I've also talked about this one, so I'll sum it up relatively quickly. The Hobbesian part really comes from Thomas Hobbes, 17th century political philosopher. Hobbes really had a sort of dim view of human nature. He thought we were all basically self-interested agents really working to maximize our own interests, so we put ourselves ahead of everybody else. This is the predators part, that really, when we look at a democracy, what do we see there? Well, it's not a bunch of people trying to cooperate and work together to build a better world and to be better off altogether. Really what we have is a bunch of self-interested agents running around trying to maximize their own well-being, which of course they might be doing at each other's expense. So on this view, and this sort of line of objection, the reason we have charters in the first place is precisely to enshrine certain rights to protect us from these Hobbesian predators running around, these fellow citizens who would want to prey on us, say through the legislature. So thank goodness we have certain rights enshrined to protect us from these people. Now, we heard this out of Waldron as well, and really Waldron says, this kind of attitude towards our fellow citizens really stands at odds with the normal respect for persons that we think is a precondition for democracy. We need to think of persons as rights bearers, as autonomous, as being able to rationally engage with arguments about what's in the best interest of the communities and make decisions on the basis of that. These sort of Enlightenment ideals of what people are really like and how they can be trusted to govern themselves. So this argument we saw really in Waldron. We heard some more about it. I've already talked a little bit about it earlier, so I'm not going to really say any more about it here, but it's just that there's this tension in this particular kind of view of why is it a good thing to have a charter? Well, that presupposes certain sort of dismal views about our fellow humans that is really incompatible with the sort of view we have to have of them to be democrats in the first place. Third, judges as Platonic kings. So if you know your Plato, you know that in the Republic, there it was proposed that the best sort of leader for society would be a kind of philosopher king, someone or some group of people who really know the truth. They have full knowledge of what's really best and what's good, and thus how we should act and how we should organize our communities, versus, say, just the common people who have beliefs about these things but don't really know what they're talking about. So they don't really have justified true beliefs. They have some certain beliefs, they might be true or not, they might have certain justifications or not, but they certainly don't qualify as knowledge. Now, on this view of why it's worth having, or why it's not worth having rights enshrined in a charter, basically the argument runs something like this. Judges aren't really philosopher kings. They're not Platonic kings. They don't really know better than the rest of us what rights we should or shouldn't have, or what's really best for the community overall. Judges, just like the rest of the people in a democracy, disagree with each other. They have sometimes reasonable disagreements, sometimes unreasonable disagreements. But long story short, judges and what they do is really just a microcosm of what's going on in the broader community. So we're not getting anywhere by appealing to judges to settle these serious disagreements we have. We're just duplicating those disagreements and then allowing them to be decided in a way that's binding on the whole community by a very small group of people instead of allowing the community at large to decide. Fourth, judges and the elites of society. This in some sense follows up on the third argument, but it's a bit of a separate argument. Not only are judges not Platonic philosopher kings, as argument 3 claims, but in fact, judges tend to come from a very particular sort of background. They tend to come from elite backgrounds within any given society. So they tend to be from the most privileged classes. They tend to come from a wealthy background, tend to be from whatever the racial majority, religious majority of the society is. And so ultimately what those judges are going to wind up doing is not only, in some sense, reproducing the debates of the community at large in a smaller setting, but there's actually going to be bias introduced into that smaller setting as well, because the judges themselves are going to have attitudes informed by their elite status. So they're going to be even less representative of people in general if, in fact, the elites of society are overrepresented in the judiciary. So this argument really picks up on a sociological dimension in what sort of people are the judges in a given democratic society anyways. Fifth, the threat of moral nihilism. The very short version of this argument is that what charters are trying to do is help safeguard what really should what should our rights actually be. They're trying to safeguard really our best view on what sorts of rights everybody should have, and make sure that that can't be overridden and that the community can't go wrong, say, when we've got some majority who is misguided or perhaps in an alarmed state or something due to something that's going on around them or something like this. Moral nihilism is just the view that really there are no correct answers to moral questions, right? There just are no moral truths. And if there are no moral truths, then there can really be no benefit to enshrining certain rights in a charter, because there is no correct view about what a right should be. So putting rights in a charter isn't really safeguarding rights, ones that we really should have, or some of the correct rights or anything like that, because all we have are competing answers to these moral questions, none of which are truly correct. So constitutions really aren't serving any kind of function here. All we have are different beliefs, none of which are really better than any others. 6, the threat of radical dissensus. This is another one of Waldron's arguments, and we heard at least some of this last time. We're going to see Waluchow pick up on this in our video next day. The threat of radical dissensus is really the threat that we radically disagree on basically everything within a democracy. We saw this certainly near the end of Waldron's piece last time. Not only do we disagree on what rights we should have, we disagree on how those rights should operate, how they ought to be weighted, how they ought to trade off against one another, and we disagree on what procedures we should even use in settling our disputes about what rights we have and how they should be weighted and how they should trade off against each other and how they should work in practice and so on. So not only do we disagree on the rights, we disagree on how to settle questions about the rights. So the way this argument goes is really, and we're going to see Waluchow pick up on this more later, because there is so much disagreement, we really don't have the kind of agreement we would need to establish certain widely agreed upon rights within the charter as a kind of Ulysses mast or sort of safe zone or foundation. So okay, sorry about that. I just saw a glaring typo on the screen, which you can probably easily detect now that I've paused and unpaused the recording of the video. So getting back to what I was saying, there's this threat of radical dissensus. If we widely disagree on basically everything, then there's no sort of zone of agreement we have that we can treat as this kind of safe spot, right? This set of rights, say, that we put into the Constitution, we at least have this settled. Now we can disagree about everything else, but at least we've got a starting point. Now, one metaphor to try to capture this is Ulysses' mast. So if you've read the Odyssey or you know about it, Homer's Odyssey, we have this character, Ulysses. Part of what he's trying to do in getting home with his ship crew is they have to go by the sirens, and you probably know this. So Ulysses knows ahead of time that as they go by the sirens, when he hears their call, right, he hears their song, which is going to give him information he needs to get home. So he has to listen to it. He knows he's going to be driven mad with desire and want to go to them no matter what. And what the sirens do is that they attract ships this way, right? They sort of sing their beautiful song and they attract ship crews, which then crash along the rocks, which is exactly what the sirens want. So what Ulysses has his crew do is tie him to the mast. So he knows ahead of time he has to listen to the song, and he's not going to be able to control himself. He's going to want to go toward the sirens and tell his crew to do that, all this sort of thing. So he has them tie him up to the mast of the ship, so he's safe and secure. He leaves his ears open so he can hear the song and learn the information he needs. He then has the crew plug up their own ears so they can't hear the song and they won't go mad, so they can keep piloting the ship. The whole moral of the story, what this, Ulysses tying himself to the mast is really supposed to represent, is a pre-commitment strategy where we know that in the heat of the moment, we are not going to be able to restrict ourselves from doing something. Think again back to when Waldron was talking about this and say gambling or something like that. Having a pre-commitment strategy. I'm only going to gamble $200 today or something like that. That's really what the Ulysses mast metaphor represents, that kind of pre-commitment strategy. Now, the way Waldron's argument goes in this threat of radical dissensus is that we disagree about so much, we don't have anything like a mast to tie ourselves to. We can't, the way Waluchow puts it, we can't find the mast. We don't even know what it would look like because we don't know what sorts of basic rights we're supposed to have. We don't know what safe is. Right? We've got nowhere to hold on to, so to speak. Now, Waluchow cites Waldron on this, which is sort of just this little bit. This is on 296. And Waldron says this. He says, "My theme in all this is reasonable disagreement, but I cannot restrain myself from saying that anyone who thinks a narrative like this is appropriately modeled by the story of Ulysses and the sirens is an idiot." This is really where Waluchow is taking inspiration for his title. That Waluchow himself is really taking the position of an idiot and saying there really is something to this metaphor of Ulysses tying himself to the mast that is in fact informative about the role of charters within a constitutional democracy. And that helps tell us why having a charter like that really is a good thing after all. So we'll see that as we move forward. So seventh argument, so it's just two more. The seventh argument is about the futility of results-driven arguments for charters. This, again, goes back to dissensus and disagreement. If we take a kind of consequentialist view and we just focus on what sorts of results we want to get in our debate and our social arrangements and so on, we might say, well, look, a charter is a good sort of thing to have for instrumental purposes because it helps get us the society we want. And Waluchow cites Dworkin on this a little bit. The argument here is precisely that we aren't sure which results we want. We have disagreement on that as well. So we can't justify the use of the charter by appealing to certain instrumental goods it will give us in securing a certain way society looks, because we can't agree on how we want society to look after all. Eighth and finally is a debate concerning charters and the level of public debate. Here again, we saw some of this out of Waldron. One argument for charters is that by having them, we actually heighten the level of public debate by articulating certain reasons into certain forms that people can then learn about and debate about in some kind of shared language. The argument to the other side, and this was really Waldron's argument, is that this produces a certain artificial fixation on language that isn't really helpful to the spirit of public debate. So if we look at, and Waldron gave this as an example, if you look at, say, the American Constitution, whenever there are questions about rights and rights enshrined in the Bill of Rights there, what you get are weird arguments that get really fixated on certain forms of language, such as whether or not a certain kind of activity counts as a form of speech, or what it really means to keep and bear arms, say. So there's a certain verbal formulation put into the Bill of Rights, and then any kind of discussion about, say, the limits of speech and expression wind up really boiling down into arguments about what that document already means, instead of having substantive debates about really what we should do, and then determining whether or not that document is right afterwards. So the argument against charters is really that you really get in the way of vigorous public debate by having things already formulated in a particular sort of language. Okay, so here are the 8 arguments against the use of charters. We're going to see in some way, shape, or form Waluchow try to answer all of these in his own set of answers to the questions that we had before. What role do charters play? Is it really a good thing to have them? Should we use judicial review as a way of implementing that charter, about having it actually used in society? How should that judicial review work? So when we hear some answers to those questions, we're going to see Waluchow trying to answer these various arguments, even if it's not always explicit. You know, I'm answering argument 1 or something like that. There's material in there against all of these. Okay, so this takes us to Waluchow's alternative conception of the role of a charter within a constitutional democracy like Canada or the United States or something like that. So as Waluchow tells us, this alternative conception takes its inspiration from 2 sources. Hart's thoughts, oh goodness, I found another typo, which you're probably gonna notice. I fixed it now. Okay, so Waluchow tells us this alternative conception of the role of the charter that he's gonna develop takes its inspiration from 2 sources. Hart's thoughts on the move from the pre-legal to legal world, and an idea articulated long ago by Lord Sankey in Edwards, which is really the living tree metaphor for the Canadian Constitution. So that Edwards case is also known as the Persons case. This was a case in Canada back in really the 1920s. There's this debate going on about whether or not women could be appointed to the Senate. And really the central question was whether or not women counted as persons according to the British North America Act, which is really the foundation, the Canadian Constitution effectively, back before we called it the Canadian Constitution. And so there was this question, very short version of it. A woman was going to be appointed to the Senate. That wasn't allowed. There's similar questions about whether or not women could be judges and so on. It was decided that no, the word persons in the British North America Act didn't apply to women. This ultimately went up to the House of Lords in Britain, which was really the Supreme Court in Britain until 2000 and something, when I forget off the top of my head. It was after the year 2000 that Britain actually established its own Supreme Court. Before that, it was the House of Lords, really the upper chamber of Parliament. So basically like the Senate in Canada. That was actually the highest judiciary as well. So it was the highest court of appeal. And of course, Canada not holding its own constitution and not having basically full political independence, had to appeal to Britain to have these sorts of issues settled. And so Lord Sankey was really presiding judge in the House of Lords over the Edwards case, and provided this living tree metaphor for the Canadian Constitution. And we're going to see what that means. We're going to hear a little bit about that today and some more about it next day as well. So we've really got these 2 sources Waluchow wants to draw on. We're going to hear a little bit from Hart first. Then we're going to hear a little bit more about this living tree metaphor and how these 2 things come together to give us a different conception of the role of a charter than is the usual shared conception that he outlined back in the first section. So, thinking about Hart, this transition from a pre-legal to a legal society. We saw this in Hart when he was talking about the sorts of problems you get in a pre-legal society. You've got issues surrounding what the law really is, what sorts of rights people have, what sorts of duties there are, what the law really is, how that changes, and who gets to decide whether or not a law has been violated. So the transition to a legal society from a pre-legal society, Hart claims, is characterized by adopting secondary rules of recognition, change, and adjudication. So that secondary rule of recognition is really that rule, which might be pretty complicated and it's rarely fully spelled out, of how we recognize who actually has the power of deciding when the rules get changed, new rules get implemented, when the law changes, when there are changes in rights and so on. And so really recognizing sources of law. There's also rules concerning how those laws change. So what sorts of procedures have to be gone through to actually implement some kind of change in law, and how these matters get adjudicated. So really having something like a justice system, having committed judges to hear cases, or trials by jury, or whatever it is, having some set of rules that really govern how law is going to work within a society. And that's how we transition into a legal society. Law starts to be governed by these rules. And then, of course, the law itself is, according to Hart, this set of rules that then applies directly to our behavior. Now, adopting these secondary rules solve a lot of problems. They solve the kind of conflict we can have by not recognizing some single authority or single set of authorities that determine what the law is and how it operates and how it's going to change, and when it's actually been followed or not followed and so on. So adopting these rules overall is a good thing. It's better to be in a legal society than a pre-legal society. But there are also dangers that are posed by being governed by these secondary rules. One danger is the possibility of a divorce between community standard and the legal standard. So once we have these secondary rules of recognition, change, and adjudication, as Hart sees it, being a positivist, what you can get in a given community is that what the law actually is determined by the procedures embodied in the secondary rules. So whether or not you've got something that's legally valid, some law enshrining a right or a duty or something like this, that's a separate question from whether or not the community as a whole, or the majority of the community, thinks that that's how things should work. So if you're in a pre-legal society, what the majority of the community thinks is right and what is being enforced as right works out to be basically the same thing. Though, of course, as you get into situations where you have disagreement between those, you disagreement between community members, you're going to wind up getting conflict, inefficiency, and so on. So adopting the secondary rules helps solve one set of problems, but it introduces potentially a different set of problems. That what the community at large wants and what the law is doing might wind up coming apart over time. The second danger is that the application of legal rules, whatever we come up with in terms of valid legal authorities, creating new rules or changing them or whatever it is, so changing what the law is, applying those rules themselves without any use of discretion or good judgment can lead to very undesirable consequences. So you can have a legal system that's set up in a way where tests of legal validity tell you that certain rules or certain laws are valid. Those aren't what the community at large thinks it would be appropriate or correct. You can also have situations where a legal rule or just sort of a law in general, thought to be generally correct and then applied to a given situation, actually produces a very undesirable result. So the second danger is really a danger of sort of formalism, of not realizing that in particular situations, a general rule can have undesirable and unforeseen consequences. So ultimately, from reflecting a little bit on Hart and these changes from the pre-legal to the legal society, the advantages it brings and the risks it also brings, Waluchow concludes with Hart, really, so he's agreeing with Hart, that we need to benefit or balance the benefits of a legal society against the potential dangers. So we need to strike the right balance where we avoid as many of the dangers as possible while reaping as many of the benefits as we can. Okay, so what is the right balance then? We've got these different sorts of dangers, and we've got the benefits we're going to derive. A very nice way to sum that up is that what we really want to do is get two things out of our legal system. We want fixity, or a certain level of stability and predictability. That is just absolutely essential to have any functioning legal system. But we also want a degree of flexibility. This is really the ability for that legal system to adapt and change over time. So we want the legal standard itself to be something that can change sort of with the community standard instead of just coming apart. that helps avoid that first danger. We also want a system that is flexible in the sense that when we encounter unforeseen situations, we're just applying some law or general legal rule without really fully thinking about it would produce bad consequences, that we have the flexibility built into the system that allows competent people, exercising good judgment, maybe we'll call them judges, to be able to look at a situation and say, right, when this legal rule was formulated, it had these good intentions, it's supposed to give us this kind of benefit. Obviously, in this kind of situation, it's not doing that, so this rule doesn't apply in this kind of situation, right? Being able to work out the details of how the legal system really functions in practice. Because of course, when people are legislating and trying to make new laws, they just are not gods. They don't have infallible knowledge and great foresight into the future, knowing everything that's possibly going to happen in all possible situations where this rule might be invoked and try to be used. So one way to try to get these desiderata, right, desiderata, things to be desired, is to just avoid charters altogether. This is really Waldron's solution, right? If you avoid charters altogether, you really get maximum flexibility. What fixity do you get? Well, you get whatever fixity there is in the actual views of the majority of the population at a given time. The way Waluchow sees this, though, is that by going with avoiding charters altogether, you're really maximizing flexibility and minimizing fixity to some extent. And if you go for a fixed charter that has no provision for change at all, it's just a fixed charter, really you're privileging fixity far above flexibility. You're really, Waldron is correct in some sense that if you have a charter with absolutely no mechanism for changing what's in it, then you're really limiting the flexibility of that society and its legal system. This is where Waluchow really is introducing his alternative conception of a charter. We're going to hear a little bit more about it yet. That this living tree or common law charter can provide really the right balance between the dangers and the desiderata that Hart outlined. And so really strike the right balance between fixity and flexibility. So a living tree or common law inspired charter is a kind of, as Waluchow thinks of it, it's a sort of humble declaration of the rights that we take to be most fundamental, along with an acknowledgement that we just don't have all the answers. So it's a way of articulating at a given point in time and really producing, in a symbolic way, an articulation of a community's most deeply held values, while still admitting that we don't know everything, that we still have a lot to learn, that over time we might realize we were wrong in how we were thinking about some of these things, that we just failed to recognize that certain rights should be taken as fundamental and crucially important. We might, just like in a legal system, come to realize that we didn't fully appreciate the implication of the various rights that we thought people had and what those would look like. Just like in producing some legal rule within a legal system, we might not fully appreciate all the potential implications or ramifications that rule might have, for better or worse. Okay, well, need to move myself a little. So, this living tree conception that we were just talking about, this one that comes up in the Edwards case or the Persons case, it's the same case, it's just referred to a couple different ways. So this living tree charter or common law charter, these are two ways of talking about the same kind of conception. What's really going on here is that this living tree conception of the charter is one that really mimics how the common law works more generally. So the common law is developed through numerous sources. We've already seen this early in the course. Of course, precedent, previous decisions, statute, custom. Now, the common law provides a degree of fixity over time. And so really, the common law is trying to meet these two desiderata in a legal system, fixity and flexibility. So the common law allows for a degree of fixity through the doctrine of stare decisis, so really the doctrine of abiding by precedent from before. This provides that degree of stability and predictability. What's going to happen in the future? Well, if we can look to the past and find similar situations and see what happened there. We're going to know ahead of time what is likely to happen in the future. Right? Now, of course, the common law itself isn't completely static, right? It's not totally fixed. It's not entirely stable. There are mechanisms for change. Precedents can be overruled. Depending on exactly how that system works, it might have to be done by a higher court, maybe not. But precedents can be overruled. Generally speaking, we work on the basis of precedent, standing with what came before, but that's not always the case, particularly over time as we see, say, the community standard has changed or something like that. And of course, new statutes, new pieces of legislation, changes can be enacted in the law through the will of the people and their representatives in a legislature. So the common law does provide for fixity, but it also provides some degree of flexibility. It has both change and stability, right? It's got both. The common law charter or living tree charter is going to operate in much the same kind of way. It articulates, for now, what we take to be our most important values, our most fundamental values, while leaving the door open to possible change at some point in the future. Based on what we now believe to be those most fundamental values and so on, there are certain limits put in place in terms of what new rulings or what new operations of the legal system there can actually be. Just like if you're thinking within the common law system, if you already have a certain kind of precedent that comes before, without a certain very sort of important move of actually striking down that precedent and just changing course, which is a pretty important change within a legal system, there are certain limitations enacted on what future judges can do. Similarly, if you've got a living tree charter or a common law charter, what you have here are certain restrictions on what a legislature can do or what a judiciary can do based on what's come before, what's been put in the Constitution. There are still some mechanisms there for changing it as long as we allow for some kind of way of changing what's going on there, which Waluchow absolutely thinks we should. So this gives us some of the tools that we're going to need to really see how Waluchow's version of the charter is going to work out differently than he thinks Waldron's view is. So ultimately, in practice, Waldron thinks we shouldn't have a charter, even if it allows for a degree of flexibility. We should just allow legislatures and the majority of the people acting through them to determine what rights are in the normal sort of way. We're going to see Waluchow argue to the contrary. So we're going to see him next time responding to some of those arguments that we saw in section 2. We're going to see him respond more directly to some of Waldron's reasons against charters. And we're going to hear a little bit more about how this alternative conception of the charter as a living tree helps provide answers to some of these objections, provide responses, and really gives the reasons that Waluchow wants for why it is that adopting a charter is a good thing, why that it has an important role to play in a constitutional democracy, and why, in fact, judicial review within a constitutional democracy like Canada is actually a good thing to have. So we'll hear more about all of that on Wednesday in my next video, and I hope you're all doing well, and I'll see you more on Wednesday. Bye for now.